Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me as always is my co-host, Senior Associate from MBK Chapman, Sam Kill. Sam?
Morning, Mike. How are you?
Good morning. I'm fine, thank you.
Glad to be with you.
So, Sam, once in a while, and maybe not once in a long while, kind of frequently, we have PCs that come in and ask us, or they write into us, or they've written into YouTube, or in many ways people can get a hold of us asking about dissolving their HOAs. Mm-hmm. It's kind of a hot topic for some reason. And I decided recently to do a couple of articles on it. One of them, I did a fact sheet on the mechanics behind dissolving an HOA, so the legal mechanics and the practical realities, mm-hmm. which make it, and I'm going to go ahead and give it away, virtually impossible to do. Okay.
Very difficult, yeah.
But
mm-hmm.
that's what we're going to talk about today. Mm-hmm. I also did another fact sheet, another installment in my ongoing saga of the bad HOA lawyer out there, mm-hmm. because that individual did a podcast recently where they discussed this issue and just made a mess of it, which I guess is par for the course when you've got your marketing director as your co-host. But anyway, it was just so badly done that I decided to write a fact sheet on that and to point out the errors and the omissions and the simplification that they went through in their very superficial discussion. But today we're going to cover basically what I did in the fact sheet. I will put in the description, I'll put a link to both fact sheets.
Okay, good. And
you can read whichever one you want. One of them is more entertaining. One of them is more informative.
Mm-hmm.
Okay? So when we talk about dissolving an HOA, what people are really asking is, I don't want to live in an HOA anymore. I want to get rid of it.
They're disenchanted. They just want to move on. Yeah.
That's what they're
mm-hmm.
doing. So
mm-hmm.
they ask, is it possible? Well, the answer is yes, it is possible. But as we're going to talk about today, in most circumstances for most HOAs, it is so difficult as to be virtually impossible. Okay? And I will explain what I mean because there's a nuance there. And I say most HOAs because there is a higher possibility of it being doable in a very small HOA. In my opinion, and this part is opinion, I always tell you when I'm speaking about opinion versus the law. In my opinion, when I say a very small HOA, I'm talking about an HOA with maybe 3 or 4 members, max 5. Mm-hmm. Okay, but under 5 typically is what I'm talking about. Okay, mm-hmm. Because every time you add, there's, as we're going to talk about today, there's so many repercussions. Even if you get through some of the mechanics of it, it's so impractical as to make it's going to make your problems worse. Mm-hmm. Okay, so let's first, just for a minute before we kind of finish what we're going to talk about today, let's go into the impetus for this. There's really only one. People are sick and tired of living in their HOA because, for whatever reason, it's very unsatisfactory. They have a bad board, they feel like their rights are being trampled, or they just want unlimited freedom. Okay, and they want to do whatever they want with their house, and it doesn't matter that I bought into it knowing I was buying into an HOA. They want out. Mm-hmm. That's really the impetus. I can't think of another reason why somebody would want to dissolve the HOA other than I don't want to be trapped or my HOA sucks. Mm-hmm. Okay, so dissolving an HOA, as we're going to talk about today, is so much more complicated than just dissolving. For the most part, it's going to be a corporation dissolving the corporation. That's easy. Mm-hmm. That's dissolving the corporation is just step one. Now, that process of dissolving the corporation is not an easy one.
The winding up process, yeah.
That's one of the mm-hmm. mistakes that the other podcasts made, is they talked about that just being, I think they said something along the lines of just file a paper. No, that's not how you dissolve a corporation in California. There's a lot more to it. We'll get into that. Mm-hmm. But that's just step one, because that's not the hard part. Mm-hmm. And it's hard in this kind of corporation. It's not so easy.
Right.
We're going to get into why.
Yeah.
It's hard, and that's the easy part. Okay? Mm-hmm. The hard part is getting through all the rest.
Correct.
And then and it's one thing after another you're going to see. And any one of those could kibosh the whole deal.
Multiple barriers.
Exactly. That's
Yep.
even better. There are multiple barriers to exit, okay?
Yeah.
And any one of those barriers can be fatal
Right.
to the attempt. So today we're going to discuss why dissolving an HOA in California is legally possible, but rarely practical in real life and practice, okay? Or I would say, in the parlance of normal terms, it's possible, but not possible. And when I say the second possible, I'm using it in normal parlance. When we say something's, that's not possible, we're not talking about physics of possibility. We're talking about, is it actually going to happen?
Right.
The answer is probably not. And there are legal restrictions, there are property-based restrictions, there are just so many. So let's get right into it, okay? And I guess the part I was just saying, I guess I have a better way of saying it, and that's that whether you can dissolve your HOA, you need to separate what's legally permissible and what's realistically achievable.
Correct.
That's really what we're talking about.
That's
okay?
a huge distinction too.
I should have probably just phrased it that way, so I apologize. All right, so let's start with California law, and we're talking about the Corporations Code and the Davis-Sterling Act, so we're kind of talking about both, does allow for the possibility of a dissolution of an HOA, okay? It is possible, but there are significant structural barriers, okay? So to understand those, you got to start by what is an HOA. Well, at its most simplistic level, an HOA is a community where there are a recorded set, recorded meaning it's recorded with the county recorder's office and part of the public record. There's a recorded set of codes, covenants, conditions, restrictions, covenants, conditions, restrictions. There are different ways of saying CC&Rs, okay? And that mechanism exists to maintain, at least in part, common area, which is owned typically by the corporation. We're not going to get into the exceptions like co-ops. Okay, typically it's the corporation owns the common areas and everybody else owns their individual units, however that's defined.
Right.
Okay. And in that world, that recorded set of restrictions, those CC&Rs, I guess present the first barrier because you have now recorded for the public a governing set of rules and regulations.
Conditions, use restrictions, oftentimes referred to collectively as a declaration. So you're declaring to the public,
That's right.
right?
Exactly.
And giving constructive notice by virtue of the recording that you're subject to those.
And all of those conditions and restrictions and those covenants that are set forth in that declaration are what we call in the law, they run with the land, meaning that they don't just apply to you. If you sell your property, they apply to the new owners automatically.
They survive transfers.
It survives all transfers of any kind because it's public record. Everybody, whether they read them or not, whether they're, I don't think you can realistically claim you were unaware because it's mandatory to, it's one of the trust, on the disclosure statement, is this part of an HOA? But you are under what's called constructive notice. Whether or not you actually know is irrelevant. The law says you know, okay? And that public record, that declaration, that recorded document is that first barrier because all of the things that are in that 100-plus page document are now, those are covenants, okay? Those are more than just a mere little promise. Those are covenants, okay? And let's assume for the purpose of today's discussion, this isn't the case. HOAs don't have to be incorporated under California law, but I can't independently, as I sit here today, remember an example of one that wasn't.
The overwhelming majority are.
Overwhelming majority. So we're gonna,
nonprofit mutuals.
Right. Yeah. So we're gonna assume today, for all this discussion, that your HOA is a nonprofit mutual benefit corporation. Either it's just nonprofit corp. Okay. Yeah. We're going to assume that. If that's not the case, okay. This episode might not be for you, but since it's going to apply to 99 0.95% of you. I'm going to just make that assumption, okay? All right, what is the first? So let's talk about the possibilities. Let's talk about, yes, what is the first step that has to occur?
Well, the first step would be the board would need to convene and pass and adopt a resolution regarding the dissolution or dissolving of the entity.
Okay, of the corporation.
Of the corporation.
Now remember, an HOA, because I just got finished saying you don't have to be incorporated, right? Which means you can be an HOA without being a corporation. The reason that's important is when we talk about the HOA, usually we're talking about both the organization that is established by definition of the recorded covenants, the CC&Rs, and the legal entity, the nonprofit mutual benefit
That's
corporation.
registered with the California Secretary of State.
Exactly.
Yeah.
Those are usually just kind of combined. So when we talk about the HOA, we're really talking about both.
Correct.
We're talking about the corporation, but they really, when you refer to HOA, you could be referring to two separate things. Now, in the case of a corporation, it's the same thing, but it's two parts of the same thing.
And to be clear, what you're not referring to is the board. You're referring to the organization or the entity.
That's right. The board just runs.
Yeah.
Okay, they're in control of the entity. But when we speak today of the HOA, we need to separate when we're talking about the corporation entity and when we're talking about that organization that was established by the recording of the CC&Rs. Okay? We will need to separate those just for today's conversation.
Right.
That's why
It's a technical distinction, but it's important.
It's a technical distinction without a difference, except when you're talking about this.
Exactly.
In everyday parlance, it's a distinction without difference. It doesn't matter. Okay? So, you're right. Corporations Code 8610 says, okay, if an HOA, the first step to an HOA dissolving would be for the board to get together and say, we should dissolve. Okay? That's a good first step. The board's in control to some extent, right? So there you go. Okay. Now the next step under the same code section is they have to initiate that dissolution process. So once they've approved that dissolution of the corporation, they have to put it out to the homeowners because the board by themselves, the directors that are elected, cannot on their own make this decision as a board.
No.
They have to start the process, but then there's an approval involved. Now, I'm going to give you the general rule, and it's by operation of Corporation Code 8724. I'm going to give you the general rule, and I'm going to let you know up front there is an exception. We're going to cover that in a few minutes. So until I tell you what that exception is, just accept this percentage. It requires 100% unanimous approval of every single member in a secret ballot election. Okay? Like anything else, any other kind of election in the HOA, whether you're voting to approve a special assessment or a director, it's all secret ballot. You have to have 100%. Now, I want to be clear about something. Getting 100% for every individual you add to a group that's voting, you increase non-mathematically, but exponentially, the difficulty of getting unanimous approval. I'll say this. There's still a healthy percentage of Americans who think Elvis Presley's working at a gas station in Kalamazoo somewhere, okay? In other words, getting 100% of any decent-sized group to do anything is almost impossible.
Oof.
Okay?
Yeah.
So there's your first huge barrier. You have to get one holdout.
Yeah.
Fails. Period. End of story. So let's talk about the exception for a second. Okay? You indicated that earlier on. I indicated that there was an exception, and there is. Okay? It's a very limited exception to that 100% threshold rule, but it is an exception nonetheless, and that applies to what?
It applies to communities that are less than 5 units or homes.
So less than 5, meaning?
1, 2, 3, or 4.
Right.
So it's limited to HOAs that are extremely small, under 5 homes.
Right. Under 5, meaning it's only 4 choices.
And to be clear, in those cases, you just need a simple majority of the vote to dissolve. You don't need unanimous consent or 100% approval, by the membership. And so technically in a community of 3, let's just say under 5, you need 2 out of 3.
Right.
And that
in
was
a community
twice.
of 4, you need 3.
Exactly.
I've never seen an HOA with 1. We've seen 2, we've seen 3, we've seen 4.
Yeah.
I've never seen 1, but if it's 1, you would have unanimous
Correct.
consent anyway.
Yeah.
Okay. But right. So 4, 3, 2, or 1, that's it. Everything else 100%. Okay? That's barrier number 1. That's a huge barrier. Getting 100% of anything, of any kind of decent size. Even 6, 7, 8 is very hard.
Well, imagine 50. One single
100.
holdout. One single holdout will
You're done.
derail the whole
Okay?
process. Yeah.
Now, there are other barriers. It's not just the vote of the membership. Let's assume you get over that barrier somehow. Okay? Or if you live in a HOA with 4, you get a vote of 3. Okay? Let's say you get over that barrier. You've got third-party approval sometimes that have independent rights to block dissolution. Okay? Governing documents, for example. Many sets of governing documents will have provisions in them that require approval, for example, from local government agency. The reason that is a thing is when if you think back when the developer's developing these areas, okay, decisions are being made at the time when the approvals are being, going through the city about who's going to own the roads or, in the development, who's going to be responsible for maintenance and repairs and all these sorts of things that go with these approvals of these big land uses, right? And you are now effectively saying whatever was all approved and done, we want to change that.
Right.
Okay, so let's assume for a second that you have a mid-sized HOA and you somehow got unanimous consent. But you have a bunch of roads in there. The city, I have a feeling, they're not going to be like, yeah, we'll add that to our budget. We'll take care of all that. Don't worry about it.
Yeah.
No, they're going to have some say in whether or not you're even allowed.
Roads, parks,
Right.
trees. I mean, the cost.
I
the
just started with
maintenance of
roads.
it. Yeah.
The point is that there are a lot of items that exist where maintenance, repair, ownership, all these things were decided, and your CC&R is a condition of all that, the granting of that, granting to the developer the right to build this community might have been conditioned on including certain things in the CC&Rs, such as you guys can't dissolve, you don't get our permission. So you might have a set of CC&Rs that requires the local government, the city, the town, whatever, to approve that dissolution. So you even get over the hump of unanimous consent, and they could say no.
That's common.
So there's one barrier, right? Another barrier that is frequently mentioned in CC&Rs, but also in completely separate documents that have nothing to do with your CC&Rs, might be a deal between you and your lender, your mortgage lender. Now, obviously, if you own your property, it's fully paid. You don't have a mortgage, this one won't apply. This little thing will be irrelevant to you. But for most of us have mortgages.
Right.
And most of our mortgage instruments, our mortgage documents, have a provision requiring, because if you think about it, their collateral is secured in this community as being part of this HOA.
By a deed of trust, which
That's right.
contains those provisions that protect that collateral. So any common area components which that HOA is responsible for needs to be preserved, maintained, right?
Because it's part of the value of your property.
Part of the value. And also, by extension, if any injury occurs, that may negatively impact the collateral.
And we're going to talk about that later. But more importantly, if anything that could affect the value of that collateral, the ability for that collateral to be sold, would damage the value of the collateral. For example, and this is one of the other things, you might have a situation where you have Fannie Mae, which backs the vast majority of conforming loans in this country, delist you if suddenly this HOA were to disappear.
And that's a huge barrier to conventional lending.
Good luck.
Right.
Because then you're just talking cash buyers.
Yeah.
Because nobody is going to get approved for a loan that isn't backed by Fannie Mae.
Exactly.
Okay, so these third-party barriers, whether it's a city or town, or a lender, or well, those are the two big ones, I guess, right? Can kibosh the whole deal right there.
Right.
Okay. Now that leads me to kind of say this. It's because of that reality that I can say that most sets of CC&Rs contain what I've termed to be a poison pill. Okay. And that poison pill is getting the permission from that third party.
Right.
Okay. And in this case, we'll talk about the city because a lot of them have that. Again, there's a reason the city conditioned its approval of your entire development back before you ever bought your house on the agreement by the developer to certain conditions. Okay. And so if you don't get that express consent from, in this example, the city, then, or the county or whatever it is in your situation, you can't dissolve because the city or county, whatever is relevant in your situation, is not about to just roll over and accept a whole bunch of assets now and liabilities that have to now be maintained and repaired and replaced and cared for and all this to the tune of many, 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 many thousands and tens of thousands of dollars just because a group of people want to dissolve.
Correct.
Okay.
And you can't do a unilateral deed or dedication without them agreeing or accepting it.
Not if it's in your CC&Rs.
Right.
Now, if your CC&Rs are silent, okay, that's different. But most aren't.
My point being, the city has to consent and approve because they're going to take over
if
any
it's
type
required.
of maintenance.
Yes.
Exactly.
If their approval is required, and it almost always is.
Right.
Okay. Now, even if you can convince the city to agree, it is unheard of for that city to do so and accept full responsibility for all costs of maintaining, replacing, repairing. They might accept some and say, but you have to maintain. I mean, they're not just going to give you a free walk. Why? They wouldn't. Now, let's go to those lender requirements, okay? Not only do you have your own specific individual lenders and it being in those general deeds of trust, which are recorded, right? And those deeds of trust are standardized if it's the general deed of trust, right? But you also have federal financing guidelines like the Fannie Mae that we were just talking about. Because, again, if they delist your property, that means that they are refusing to finance a purchase of that property. You're not getting anybody but a cash buyer, which eliminates the vast majority of potential market. Everything crashes. Okay.
And refinancing too.
Everything.
Yeah, all of it.
Okay.
Yeah.
That's refi is the same as a purchase when you're talking about that. Okay. So let's assume somehow that you've got your 100% unanimous approval by the members, and either the city is not involved at all, and for some reason everybody's mortgage doesn't. I mean, it's like there's no let's say there's no third-party barriers. Let's just assume for a second that you get over those two massive humps. Okay, all you've gotten there is okay. Let's dissolve the corporate entity. That's all you've got.
Yeah.
That's where we're at still. Okay, so Corporations Code 8710, 8713, 8618 all require, as a function, as a duty of a corporation that's closing, they have to attest under oath that they are settled all their debts, notified their creditors, and the most important one, disposed of the assets before you can say we have completed the corporate dissolution. So remember, we separated corporate entity from whatever organization was created by the recording of the CC&Rs. Only upon getting over the first two huge humps and then getting over you settling debts, notifying creditors, disposing of assets, can you say, okay, our corporation is no longer in existence. And you still have your HOA according to the CC&Rs. And that's where we're going to go next, because even after your corporation has published or communicated its final plan of distribution, and I guess before we move on, let's talk about zombie. Let's talk about the zombie, okay?
Yeah.
Zombies are popular today. Let's talk about zombie property ownership, because it's going to lead beautifully into what we're about to talk about. So Corporations Code 8717 discusses what HOAs have to do if they're considering going this route is if they adopt a plan, right? Mm-hmm. The plan has to specify exactly how the HOA is going to deal with the transfer of title to the common areas. Because remember, the second that CC&Rs were recorded, there is now common area that exists. Everybody owns their unit, whatever that consists of, but there's also common area, okay? You cannot dispose of a corporate entity because remember that corporate entity owns the common area, okay? Not individual homeowners don't own the common area. The HOA owns the common area, okay? You cannot dispose of that corporate entity if there's no plan for the common area. And this is, I guess, the next massive barrier.
Yeah.
And all those technicalities that we were hinting at the beginning, that's where they flood in. Everything we've talked about so far is the easy stuff, okay? So what I mean by zombie property ownership is if the HOA somehow declares, by filing the right paperwork, declares itself dissolved without actually transferring common area to somebody. There's still common area, okay? Yeah. Every property owner, every member of that HOA now is in some sort of legal limbo where they become potentially personally liable for any injuries, deaths, or damages that occur to somebody else or to any one of them on the common area. So where the corporation was solely liable before and no homeowner had any liability there, suddenly you have joint and several personal liability. Very dangerous. Okay, so let's talk about that because that's the biggest part of this whole thing.
Huge.
Is once you separate the corporation from that whatever organization exists as a result of the recording called an HOA, right? Even if you get rid of the corporate HOA, if you haven't done something with this common area, you haven't gotten rid of any obligations that you had that were causing all your problems in the first place.
You, in effect, have a de facto community organization.
Think about this. Yeah. Do you homeowners ever have any disputes with yourselves about what color paint you use inside your unit or what kind of flooring you have, other than, if you want hard flooring and you live in a multi-stacked unit that has rules. But I mean, the point is that all the disputes people have with HOAs relates to the board of directors and how it affects common area. Whether it's, we don't want you to build your balcony over here because you're going to affect this, right? In other words, the problems that you have always end up being tied back to something to do with the common area.
Right, exactly.
Okay? And closing a corporation doesn't get rid of the common area. It just takes away the legal entity that used to own the common area. And now that that's gone, everybody owns the common area. They better, right? But no, they don't because there's never been a transfer.
You've merely removed that designation.
So there's a
legally.
Zombie limbo.
Exactly, yeah.
Because you didn't actually transfer ownership. You just got rid of the entity where the ownership resided, which is supposed to be not possible.
And the portion affecting your chain of title is also unaltered at this stage.
But you have mucked up title a lot, though.
Yeah.
You've really mucked things up, okay? So this is where we get to Business and Professions Code 1100 4.5, so 1004.5. And that requires common interest developments, HOAs, to have a mechanism in place to maintain shared property and fund those obligations. Now, if you recall, a long time ago, and I may or may not put a link to this, I haven't decided, but if I remember, I will. We talked about how one of the obligations of an HOA is they must not only maintain, repair, replace common area, but they have to charge enough, whether it's in the form of general assessments or in combination with special assessments. They have to collect enough money, whatever it takes, to discharge those obligations. So whatever it costs to repair, maintain, and replace common area, they've got to get from the members.
Right.
The obligation to say, give us money, is a legal obligation. It's not just a choice that HOA boards can make or not make. They have to make it.
Agreed.
So if it costs $5,000 to do X, Y, and Z that's required, then they better collect at least they have to collect $5,000 for that. Okay? So why is that important? Because if you get rid of the corporation, if you get rid of the mechanism that allowed for the ruling, the board of directors who are in charge, and there's a whole legal mechanism of how they are supposed to operate, what their powers are, what their limitations. If you've taken that away, it takes away the mechanism that they were able to do what they did, but it doesn't take away the obligations at all.
Yeah.
Give me a reason why that's crazy. What?
Well, one reason that's crazy is because you're gonna foreseeably and almost certainly have a state of chaos. And unless you have those instances, let's say our exception was the less than 5. If you still have a very small community of, let's say, 6, 7, 8 homes, and everyone unanimously agrees, and they're the most fantastic get along types of folks, and they get it done. That's the exception too.
And getting it done. We're going to discuss what that means.
Everyone they do their part. They pitch in or chip in, whichever form you should go with, and they carry their obligations. They maintain all of the common areas and kind of mutual obligations, so to speak. That's the exception.
Before that,
yeah,
they can't just do that. There has to be a legal transfer of ownership.
Yes.
The HOA owned the common area. When that corporation is closed and over, there better have been a legal recorded transfer of all those common areas to blank.
Blank, right.
Okay?
Right.
So, who would it go to? Probably the other homeowners. What does that mean for? Let's think this through for a second. Let's think this logically. You have a corporation that owns the common area. You own your unit. So you have rights to that common area by virtue of the fact that you are a member of that corporation. Not necessarily a shareholder, but because it isn't discussed that way, but technically that really is what it is. Okay? But you had a mechanism in place. You had the HOA owns the property. HOA maintains, repairs, replaces, collects money from you. That's how things worked, and there are legal limitations and obligations of the board in fulfilling their duties. You've now taken that corporate issue away, and you've transferred the common area to, let's say there's 6 of you, to the 6 homeowners. So now you've transferred all that common area to the 6 homeowners. Well, how have you transferred it? We're going to cover part of that later on how it's done to places that have actually done it, how they do it. But what you're doing, if you think about it, is you're just trading one form of common ownership for another form of common ownership.
Yeah.
You're not getting rid of anything. You're not getting rid of any problems. All you're doing is changing form. But the idea is identical. Somebody owns the common area and somebody has to maintain, repair, replace, and be liable if things go wrong, including somebody slipping, falling, and dying, whatever. Somebody owns it. And if it's not the corporation, then it's somebody else. It could be somebody's else or somebody else, but somebody owns it. And somebody has to pay. And somebody has to get money for it. But you've taken away the most common and the easiest form to allow all that to happen, which is a corporate form.
Right.
We'll get to that later.
Yeah, I suspect at its core, it's really a desire, a sentiment, an impulse, any word you want to choose, to remove the board of directors.
Yes, it is an emotional.
Right.
When people say, I want this HOA gone, I want to dissolve it, they're often saying, I can't stand this board of directors.
Yeah.
Now, if you're one of those people that says, I think everybody should own their own home and should be able to do whatever they want, paint their house pink and neon green and all that, and be damned with what anybody else wants, that's often not going to be the majority of those people that are expressing this sentiment. But to assume they are, those are people that just need to buy somewhere else because most people don't fit in that, okay? Yeah. So here's the point we're making, and I guess we'll get to this, right? So, no, we'll cover this part. We'll finish covering this part later. I'm just going to tease, okay? Everybody needs to understand that if you've closed your corporation properly, you have transferred the common area assets to other owners or owner, and along with that transfer, all the responsibilities and legal liabilities and obligations and rights, and value. Everything's been transferred to somebody else. And then the corporation could go by the wayside. But you still have a recorded CC&Rs. You still have that an HOA as some sort of group of people. They just own the property differently than how it was set up. But now that group of people owns that property. We'll get to what do you do at the end. Let's talk about insurance, okay?
Oh, huge, yeah.
Another big barrier. We talked about the banking, Fannie Mae. We talked about your lender. We talked about the city being a barrier. Another barrier is the insurance company. Nobody in their right mind is going to operate their own properties, never mind property that they've got liability for, joint liability for common area, without some sort of insurance policy. And insurance companies are going to say sayonara. Okay? When you've got a master insurance policy that, was covering all this common area, and suddenly you've taken away the corporate form and transferred it, that insurance company's going to go, well, your policy is no longer in existence.
The risk evaluation is completely turned upside down when you remove all formalities. Now the community is no longer subject to the Davis-Sterling Act. They're not being, no oversight by the board. They're not going to underwrite that.
Or if they do, you're going to pay a lot more money for insurance. And we've done other episodes of this podcast where we talk about the skyrocketing insurance rates and the reasons behind it. This is one we didn't even talk about because it's so rarely does this actually happen that it's almost not worth talking about. We're only talking about it because people are talking about it because they don't understand what's behind getting it done. Okay? Now, so we've now, I hope you all understand now, getting rid of the corporate structure doesn't get rid of your HOA. Okay? It just eliminates the government or the enforcement mechanism that allowed your HOA to do its obligations. Okay? It took away the skeletal rule book of how it was supposed to do what it's supposed to do. It didn't take away any of the stuff that makes it an HOA. Okay? So let's talk about what people have traded. Okay?
Yeah.
So you have your corporation, you have your board of directors, you're subject to Davis-Sterling, all that stuff exists. You somehow get over all these barriers, you get rid of that corporation, you shut it down. You've transferred the common area to the homeowners that are there. Okay? Let's take it as an example, a smaller HOA, 4 homes.
Okay.
And you did a vote, you got 3 of the 4 to agree, so you got your majority, or all 4, whatever. Okay? And they got over the city problem, they got over the mortgage problem, they got over the lender problem. Let's say it's 4 people with fully paid property, so there's no mortgages. And let's say the city doesn't care because the homeowners have said, we're going to still maintain and repair. And the city's like, all right, we don't care. Let's say you got over all that. Shut the corporation down. Okay. You've transferred the common area from the corporation to the 4 of you as joint tenants.
Sure. Tenants in common?
No, not joint tenants.
Tenants in common.
Right of survivor. Tenants in common.
Yeah.
You've just transferred the HOA common areas to each of the 4 as tenants in common. Okay? What have you changed? Nothing. Well, no. You've changed things for the worse. What you've changed nothing is you now still have a group of people that as a body they own this property that there's liability and obligations for. But you've taken away the liability, the personal liability protections under the form of a corporation and just given everybody personal liability now. So thank you very much. You can lose your home if something catastrophic occurs. Because before it used to be a corporation. One of the best things about corporation is it is a method of asset protection. It is a limited liability organization so that your personal assets are separate from corporate assets. Well, you got rid of that. Now you have a personal asset. You are a tenant in common with 3 other homeowners on these portions of land or whatever, and you have personal liability now.
Yeah.
Welcome to the club. But have you gotten rid of an obligation to maintain? Nope. Have you gotten rid of an obligation to collect money to maintain? Nope. What do you do when one of the 4 of you decides later, I don't want to contribute anymore. I just like using the green belt in the pool, but I don't want to pay for it. Well, you're going to have to sue them now. You don't have any of those rights that you had before. Okay, you don't have the board of directors in place that can, start imposing. Now, I guess they could come up with a private agreement. They could come up with a written contract, right? They could.
Yeah, well, if they rescinded the CC&Rs, assuming that that's also part of the process,
well, it has to be.
There's no obligation to pay regular dues. So what they would do is then pool funds and resources and go
or send everybody a little note saying, "Hey, we need X amount."
Yeah.
So, So let's finish the process. You close the corporation and you terminate the HOA by unrecording it. All right. You can terminate the HOA.
Right.
And then on the record it shows it was terminated or died. Okay. That's fine. Let's say you've gone through that. You still own, you four of you together as tenants in common own that common area. So let's say you got to put in new. Let's say there's a huge storm and a tree falls and damages the pool and it's like $20,000 repair. All right.
Yeah.
You're going to have to go to the four of you guys and go, hey, we all remember that storm the other day. Well, that tree just destroyed stuff. It's going to cost $20,000. So there's four of us. So can we each have to contribute $5,000? And you get one of you who says, I don't want to. Well, you're not going to get it fixed unless you pay the contractor the $20,000 that they quoted you. So you got to get it fixed. But you got a guy not paying. You guys are going to have to go after him. You're going to have to file a lawsuit.
Yeah.
Okay. You might have an agreement. You say, we foresee this happening. Let's enter into an agreement together. A mutual maintenance and happiness agreement between us.
Yeah.
And we'll spell out all of our obligations. So if the tree falls, we all have to pay equally. We'll build in all these little penalties. What are you creating? I've seen this before. Wait a minute.
A tenancy in common.
I'm creating sort of another set of CC&Rs. It's just not recorded.
Right.
What do you think the CC&Rs are?
Yeah.
It's an agreement it's agreement among the homeowners about the maintenance obligations and all the things to make this thing work. You went into a private agreement. It's not recorded, but there it is.
Yeah.
Now, you might choose to record that. That might be a recordable document. Well, then back to the CC&R is just not as good. In other words, unless you have an HOA with one person, you are, by definition, going to be getting into business with the other people in that HOA, whether it's 2, 3, 4, or 60. And you're going to have to do all of the same things that you were required to do unless you say, I guess the exception would be if you as one of the four owners said, guys, I don't care about common area. You guys do that amongst yourselves. You three split the common area. I'm just going to keep my own property and I have no rights, no obligations, nothing. I will have no ownership. If they agree to that, then I guess you're free. You're free and clear.
Yeah.
Okay. But other than that, you've just traded one recordable document about managing and obligations and all that for an inferior one.
Yeah.
Which doesn't give you the same rights.
Right.
I guess the point is, we understand the impetus behind, I can't stand this, I just want to dissolve the stupid thing. I get that. Most of the time, it involves personality.
Right.
Get rid of the board, blah, blah, blah. Once in a while, it's a don't tread on me individual rights thing. And when it's that, I could see it. As the consequence is worth or the consequence is worth it. Yeah. But most of the time, it's when we hear about people saying, can we dissolve our HOA? How do we do that? It's because they hate the board. Right. So we then educate them on, there's a lot of ways to get what you want without going through all that.
Yeah.
Give me the bottom line here. So tell me, bottom line, is it possible to dissolve? Yes.
Legally, yes. So the bottom line is legally, it is absolutely possible to theoretically dissolve an association. The problem comes in practical terms because you're substituting one form of it that's typically pretty well organized, just not properly run because of the personalities at the governance stage, and you're substituting that for a state of limbo where you have a bunch of uncertainties, including transferring a lot of the same obligations to everyone co-equally.
Yes. And even if you clarify those ambiguities in the form of an agreement, you've just substituted one for another.
Right. And there are other mechanisms to really get there without going through all of this without going through having to, redesignate the entity, without having to tamper with insurance or possibly lose insurance coverage,
or
without
the mortgage or the city,
notifying the IRS of the changes you've made, notifying the Secretary of State, the city, right? Municipalities.
Yeah. Get rid of the bad leaders.
Get rid of them. You could do a recall.
Yeah.
Or could,
at the next election, don't vote them back.
Become more active, campaign. If you need changes, fundamental changes to be adopted, lobby for amending and revising your CC&Rs.
And ultimately, if you can't do that, and that happens a lot of the time, move.
Yeah. There could be a fundamental misalignment between a certain individual or personality type
and everybody
just
else.
community-style living.
That's right.
And that
yeah, you might not be individually. You, as an individual, might not be cut out for living in an HOA, and that's okay. Mm-hmm. Go somewhere else. There are places you can go. It's increasingly getting harder and harder, especially if you want to move into a home that's less than 30 years old.
Yeah.
And if you're in, let's say, Southern California, it's getting harder and harder to buy into a community that isn't governed by an HOA. And in the future, it's just going to get harder and harder and harder because HOAs are spreading like wildfire across the country.
Right.
Okay. But it is still possible. Mm-hmm. There are lots of places that are not governed by HOAs. That's where you need to move. Okay, if you're one of those people that just isn't designed for living in that sort of environment. Mm-hmm. But
dissolution is not going to be a cure-all for your troubles.
Most of the time, it's going to cause problems. So I guess the bottom line of this entire episode is, yes, dissolution is possible. There is a legal mechanism for it. But in the vast majority of cases, it is so incredibly difficult to do and impractical, even if you can do it, that it is virtually impossible to successfully and legally do. Mm-hmm. And it also is not the solution if your complaints about your HOA, are on just how things are being done. Because really what you're talking about is we need new leadership. We need a new direction. Okay, mm-hmm. Mismanagement, you're not going to solve a mismanagement problem by dissolving an HOA. You're just going to make the mismanagement problem much more difficult for you and anybody else that agrees with you to get things done properly. You're just going to torpedo the rights and protections that are actually built into the law right now for you. Mm-hmm. Okay? If you're thinking about trying to dissolve your HOA, think again. It's very hard to do, and even if you can do it, there are a lot of practical realities that could kibosh the whole deal. It's virtually impossible. But if you have a very, very small HOA, it is possible and it's doable, but you end up trading one agreement for another. You're not going to get rid of the concept of what you're trying to get rid of, which is somebody having to work with other people to maintain, repair, replace property that you have partial ownership in. That's the bottom line. If you like this episode, please hit the like button. If you haven't already done so, please subscribe to the channel HOA Hell. If you have any questions, please leave a comment. We look at those and we do answer those quite frequently. Until next time, have a wonderful day.